Hugh, in any matter that goes to litigation, we're going to be forced to go into mediation, whether by the courts or in construction contracts. Many times mediation is required before you even file the suit. So as a critical part of the process, let's discuss today what it is you can do to make a mediation successful, how to be prepared, how to get prepared, whether it's settling the case or at least helping you get prepared for the next phase.
Typically, at a very minimum, the association is going to file a lawsuit against the developer and potentially also the prime contractor. And so one of the benefits there is the association only has to prove its burden against the developer and the contractor. The association wasn't involved in the design or the construction of the project, so anything that's wrong from a design perspective or a construction project really can't be the association's fault. So typically the only pushback to the association is whether or not it properly maintained the building. And that can be relevant if the project's been in existence for a few years and maybe even reached the first paint cycle when the building should be repainted and recaulked. The other perspective is bring everyone in. And that can be very effective because if an association brings everyone in, including all the subcontractors, then the association and its counsel really control the settlement more in that scenario. For instance, no subcontractor is going to get dropped out of the case by a general contractor unless the association approves that, unless the association is receiving the type of settlement that it wants from that scope of work. And a third twist to this scenario, which is based in large part on the quality of the contracts between the general contractor and the subcontractors, is we also see associations settling early with the general contractor and receiving an assignment of the contractor's rights against all the subcontractors. That can be a very powerful move for the association because when it does that, assuming there's the right contracts in place between the GC and the subs, not only is the association a plaintiff in its own right as the owner of the project, but it's also a plaintiff standing in the GC's shoes with claims against the subcontractors and has rights to recover from those subcontractors whatever the GC had to pay to get out of the claim with the association.
Right. Let's drill down on that because that's a very important part of the process. And I want to back up for just a second to the 558 process. When the general contractor does receive a 558 notice and there's the laundry list of problems, one of the things that the contractor is going to do is figure out, first of all, is there merit to these? I'm going to go out and take a look at these. Are these real problems or are they maintenance issues? Is it the association's failure to do their work in maintaining the property? Or is this something that my subcontractor did wrong initially? And if it is, I want them out there and I will get the subs that are implicated in the 558 notice out to the job site to participate in that 558 process. Then when the lawsuit gets filed, I'll know who, if anyone, needs to be brought in as a subcontractor if the association decides to only sue the contractor. Now, what becomes critical then at that point, as you indicated, Hugh, is what are the terms in the subcontract agreements that you have? If you're the prime contractor, you want to make sure that every one of your subcontractors names you as an additional insured under their policy so that the subcontractor is essentially paying for your insurance.
Absolutely. And I think that segues into really what everyone is interested in, and that is how do you get to a successful mediation, right? We've gone through the 558 process. We've put everyone on notice. We filed a lawsuit, maybe we've exchanged tons of documents, maybe some depositions have been taken, and now all the clients are saying, when is this going to be over, right? And the association's asking, what do I need to do to get my money? The contractor and the subcontractors are asking, when does this go away? And so the critical question is, what do you need for a successful mediation? And that really taps back into insurance, right? If the association is losing sight of how the check writing decision is being made, then that's really the whole process that is being a whole part of the process is being skipped, because at the end of the day, a decision is going to be made by an insurance adjuster and potentially their supervisor or their supervisor's supervisor based on a very detailed accounting process. And that accounting process looks for what are the invoices or estimates regarding the construction defects. We want to see line by line, how much is this issue costing? Run a complete financial analysis on it, verify that it's accurate, that there's no fraud or deception or pieces left out, and then also decide, well, was our insured responsible for this problem? So it's twofold. There's a liability. Did our insured do something wrong? And then assuming our insured did something wrong or has some percentage of fault, then what are the numbers that we add up to figure out the ultimate calculation of what we're willing to write a check for?
Well, so it's an interesting point, Hugh. As in every event, whether it's a football game or a game of chess, and certainly in litigation, where there's apparent preparation and readiness on one side, it can be very intimidating to people on the other side. And when the homeowners, the condo association comes in ready and lays out their damages and said, this is it, respond and have it ready, there's the sense of, wow, this team is ready to go. They're ready to clean our clock. We better do something about this. On the other hand, when the response from the plaintiff side, making the association side making that claim, doesn't really know, we'll get it all together and we'll get it to you as soon as we can. It'll probably be the weekend before mediation. There's an indication there that maybe they aren't very well prepared and maybe they aren't really interested in trying this case, which may lead to us to believe that we probably don't have to pay all of the money out on this one to get it done. Hugh, you've introduced the concept, though, of an adjuster. And it sounds like from your description, the adjuster has a lot to do with how much money is going to be put on the table by the subcontractors and the general contractor on moving things forward. Let's talk a little bit about what the adjuster's role is. Is it really just to hold money back as long as possible and dole out, the policy limits? How does that work?
Yeah, I'm not convinced that it is. Every adjuster is a human, so there's the potential for quite a variety of differences from one adjuster to the next, even within the same insurance company. Although each insurance company does try to have specific processes that it carries out, but really, I think of the adjuster as the gatekeeper to the funds, and also really a steward of the funds, because the adjuster isn't doing a good job if they simply just write a check for the full amount of the demand without doing the right investigation to determine whether that is the amount of the damages and whether those damages are actually covered by the insurance policy. Because we have to keep in mind that insurance is a contract, and the specific terms of that contract dictate whether that contract pays in a certain scenario or not. So the insurance adjuster has to deal with these coverage issues to make sure the adjuster isn't paying money that is in excess of what the insurance company agreed to pay, when it wrote that policy and took the policy premium.
Right. So in that process, in the mediation process, and using the strategy of whatever it may be, whether it's to find out more information, to figure out where the dollars need to be coming from. I know, Hugh, you and I are both certified as mediators by the Florida Supreme Court. And I was involved in a mediation where there was a condominium association going against one of Florida's very large design build contracting firms. And I watched a process there that you may be interested in hearing about. I don't know that we've discussed this before, but the attorney for the association used the entire mediation presentation to focus on the contractor and tell what a poor job the contractor did to the exclusion of the subcontractors. Focused on the contractor failing to manage the project, failing to have the subcontractors do what they were supposed to do, and even to the point of saying it really wasn't the subcontractor's fault. A real heated, sort of a scorched earth position, but it was terribly ineffective.
Opening statements in the general session is when you use birdshot, because you want to scatter far and wide and cover as much territory as possible without, you really don't want to draw any special attention to just one party or another. You want to try to get engagement from everyone in the room during the opening session. Then now once you break out into caucus where everyone's meeting individually, now that's the time when you can have a mediator send a message to the general contractor saying, guys, by the way, this is the case where you don't get out for just paying 5 to 10% because a lot of this was project management problems, and that's going to come out in the case if this thing keeps going. But you don't tell that. You don't shout that to the subcontractors, because then they're going to go in their rooms and say, we don't need to pay anything. It's all the GC's fault. The association just said that. Mediation is one where you want to communicate accurately, but the messaging has to be accurate to the right people at the right time. And sometimes being too transparent with the wrong audience is the wrong play.
So we've covered a lot today, and we know that these cases involving construction defects, design defects, and so forth are not coming to an end, and they require a great deal of expertise. If you find yourself in those situations, if you need counsel, if your trusted counsel maybe doesn't have the experience in construction law that you feel like you need, give us a call. We'd be glad to help you and help walk you through it and perhaps become your trusted counsel for your construction matters.